Okay, thanks so much. Okay, so I'm going to share my screen, correct?
Yeah.
Okay. Okay, share. And then now I need to start slideshow. Okay, can you guys see?
Perfect.
Okay, great. Okay, estate planning considerations for separating spouses. So this is a often overlooked area that can create some serious boo-boos, I guess, for want of a better word. When, as we all know, separation and divorce is a fraught time. People are exhausted mentally, emotionally, physically, financially, spiritually, in every way. And, it's, considerations of, Maslow's hierarchy of needs, shelter, security are immediate. And often people forget actually the very, very serious implications of if they don't think about estate considerations. For example, designations of beneficiaries on registered funds, updating their wills and powers of attorney, who's beneficiary of life insurance. What happens if one of them dies in the middle of the process? And so it's actually not uncommon and around here for people to die with 2 legal spouses. And let me tell you, that's expensive and messy and something you want your clients to avoid. So we're going to go through all the fun stuff, and I will talk about all those things. So, and I know that this is a national group, but I'll talk about some of the BC law, and then a lot of it will actually apply, generally speaking, across the country. So in BC, we used to have like about 8 different pieces of legislation. And in 2014, it was consolidated and updated into one big omnibus piece of legislation called the Wils, Estates and Succession Act. So I'll chat about generally what happens in BC under that act, major estate considerations upon separation, and posthumous family law claims, and some recent cases in this regard. So as I mentioned, WISA in BC came into effect on March 31st, 2014. Before that, if you got legally married, your will was automatically invalidated. It was revoked unless the will specifically contemplated marriage. Now, if you get married, your will is no longer void. It continues to be valid, even if it doesn't provide for your new spouse. So this is something important to remember. So a lot of people get married, they, later life, they don't think about doing prenups, and they often don't think about updating their wills, at least right away. So it is possible that if you had, so say people remarry at 70, there's old wills where they left everything to their old spouse and then equally to their kids. They're married a few years, and then client dies. If he hasn't provided for a new spouse, for example, she's going to receive absolutely nothing because the old will is in force. So in BC now there is recourse. So that spouse can and likely will apply to vary the will. So we used to have something called the Wills Variation Act of British Columbia, and I know there's very similar legislation across the country. That, after a lot of contentious debate, was brought into force into the new act. And so now if you die with a spouse, which is someone you've legally married, or you've cohabited with for 2 years, and or children, including even adult independent children, they can sue your estate and say that their adequate provision was not made for them. So if you get married and don't do a new will and die without doing one, your new spouse can sue in BC under WISA Section 60. So as I mentioned, now, and you can, after 2 years of cohabitation, you are treated as if you're a legal spouse. Certainly from a legal perspective, that's awkward because you are also potentially legally married to the person that you never divorced. So it is possible to have 2 spouses. And there is this quite notorious case in BC where this gentleman who was a member of quite a notorious motorcycle gang in BC had a second secret family, So he was legally married to wife and then actually had a full, purportedly common law marriage with somebody else, kids with both, dies intestate, and he was actually found to have died with 2 legal spouses. So again, not something any of us would counsel our clients to do, but it does create interesting fact patterns for those of us that work in this area. So intestacy. So as you know, let me just talk about some statistics. So as financial planners, you know that over the next 10 years, it's estimated that approximately $1 trillion of wealth is going to transfer in Canada in the next 10 years. And the other baffling statistic is apparently half of Canadians have done absolutely no planning. So that there's going to be a juxtaposition of an enormous amount of wealth that's going to transfer. And a lot of people you see walking down the street who have done zero planning. So what happens with those people? So they actually do have a will, but it's a legislated will. So basically what happens is your estate's going to pass pursuant to the legislation of the province in which the deceased resided. So as I mentioned, you can be married to one person in common law with another. And in that Baker Gang case, which is actually Boughton versus Widner Estate, in an intestacy, the 2 spouses were entitled to 1/2 of the deceased estate. So the 2 ladies shared it. By the way, one was aware, the secret wife was aware of the legal wife, but the legal wife was not aware of the secret wife. But you can imagine she was probably highly unimpressed, but you also kind of wonder why she didn't ask more questions about where he was for probably was a quite substantial amount of time. So what happens if a couple separates? So with respect to the will. So if you have, so say husband, wife, reciprocal wills, everything to each other, last to die equally to the kids, like a pretty standard will. And then husband and wife, or it could be wife and wife or husband and husband. I shouldn't assume it's just that way. But if they split, what happens is the starting presumption is the separated spouse will receive nothing unless a contrary intention appears in the will. So say the parties are in the middle of a contentious divorce and they haven't updated their wills, and then one of them dies from maybe the stress and strain. This is all very depressing fact pattern. If what happens is the surviving spouse is deemed to not receive anything. The other thing is if people separate and then they reconcile, unfortunately under RISA in British Columbia under Section 56, the rectification does not rectify, or the reconciliation does not rectify the disinheritance. So this can create very unintended and unfair circumstances. So if you're separated, and you can actually sue the estate under the Family Law Act. So what would happen is, say that they were separated, but they'd never done their formal separation agreement and split assets. It's clear law that you can sue the estate of the deceased person and then obtain a settlement under Family Law Act legislation. If you're married, so say that the couple separated and then reconciled 6 months later and then never redid their wills. So unfortunately the spouse would also be disinherited, but they could file a claim under Section 60 of WISA, which is saying that it would just be unfair to exclude them. So basically, short answer, if you're separated, you basically divorce the estate. If you are still together, then, or together subsequently, then you sue the estate saying it would be unfair. So what happens to registered funds? So this is a very common error, and this is something that certainly people that help people with financial planning around divorce should be, you guys will probably already know this, but should be first in line to advise people. So beneficiary designations under registered funds are not automatically revoked upon separation or divorce. Therefore, unless there's a change and it's completed, as contemplated under the separation of court order, the former partner will continue to be a beneficiary and entitled to the proceeds. And also, if the spouse is no longer your spouse and they get the money, they don't get the rollover under the Income Tax Act of the original adjusted cost base. So it's actually a taxable event. But the terrible thing is your estranged ex-spouse gets the RIF, but the estate has to pay the taxes. So as you can imagine, litigation will likely ensue and be very messy and expensive. So the goal would be to get clients to, as soon as they sign that separation agreement, to make sure that they go ahead and change their beneficiary designations as contemplated under the separation agreement to avoid a messy scenario and potential tax consequences after the fact. And life insurance, similar to registered funds, it is not revoked upon separation and divorce. So if you don't change it, your estranged ex could get a big life insurance policy. So, and similar considerations apply under group insurance plans and pensions. Although, as you likely know, pensions are their own animals, and you have to file very prescribed forms and tick the boxes and all the things. And it's gonna depend whether it's federally or provincially administered and what the pension administrator things are. But I think the take-home message is that what we do around here is, like, we do wills and estates and family law. We have, once people have done a separation agreement, we have what's called the post-divorce checklist, which is, I think, the most unromantic sounding document ever, but it's basically all the list of things that clients need to do post-separation. And all these items are very much at the top of the list to make sure that you dot all your I's and cross all your T's to avoid unintended consequences. So if clients intend to name minor children as the new beneficiaries of registered plans or life insurance, that's never a good idea. And so say, you split up from your ex and, your kids are 10 and 8 and you want to take his name off and put Billy and Bobby on the plan. Bad idea. Because what's going to happen, certainly in BC, is the public guardian and trustee is going to scoop the money, actually charge a bunch of money, and then give the money to the kids at 19. So you don't want to do that. So what you can do is, there's two things you can do. You can make the beneficiary your estate, and that's clean, although, as you know, it'll be subject to probate fees. The other thing is that you can create a trust declaration. So we can basically, you could appoint a trustee, so a family member, friend, or even a professional trust company, and then concurrent with that appointment, you can draft a trust upon the terms upon which they hold the funds. So that is, sometimes it's just easier to put the estate down. I know it's annoying to pay probate fees, but it actually will save a lot of complexity and potential legal fees at the time, and at least the money will be held in trust on the same terms as the will and then given to the kids as you intend. So wills. So people, as you can imagine, after separation, you want to update your will. Not only do you want to take your ex off probably, but your financial position and assets may have changed dramatically, often dramatically less, but it could be more. But it could significantly impact gifts under the will, because your estate will likely be quite a different size than it was prior to you being separated. You may not want to provide for your ex-spouse's family members. You may need to appoint a new executor. So you're definitely going to want to revisit your will. And there's other considerations other than just sort of deleting your ex off. So here's a huge boo-boo that people do that we need to warn people about in British Columbia. So in the battle days, people would invariably buy will kits and things like that, not conform to the requirements of the old Wills Act in BC, and then the will would be held completely invalid. There was no way to fix it. And then money went to wildly different people than the estate, than the testator intended, because they wanted to leave it to people different under the intestacy. So to avoid that sort of patent unfairness, the legislators thought of something that I think they tried to create things to be more fair, but inadvertently has actually created a lot of complexity, and that is Section 58 of the Wills, Estates and Succession Act, which essentially says anything in writing that reflects a testamentary intent could be a will. And so what they were trying to say is, okay, somebody could have tried to make a will, and just because it doesn't conform exactly to the terms of the Wills, Estates and Succession Act, this is a rectification provision where we can fix it and say it's still a will. Well, the problem is people, particularly older people, will often grab, those realtor pads or Post-its, and they will scratch notes or handwrite on wills. And I think they're just sort of brainstorming. And the problem is people pass away. And I actually have an estate mediation that's coming up where mom has like 12 pieces of like realtor pads of paper where she's written a variety of all kinds of different things. And we have to put that in front of a court because you're required, because anything in writing that is deemed to be testamentary, you have to put in front of a court, and then a court has to try to unpack what the deceased meant. And the findings can be intensely context and fact specific. So what I'm saying is, post-divorce, instead of just scratching Bob out and saying, no, don't, like, I guess if you could try to coax your clients into going to see a lawyer or notary and doing it properly, and don't do any hand scratch notes, because that could actually create more complexity than the person intends. And so what happens to incapacity planning? So in BC, we have a power of attorney, which is for finances, and our healthcare agreement is called a representation agreement for healthcare. So as you know, those are two documents which allow people to plan for the possibility of future incapability. So the power of attorney is for anything to do with finances or legal, and the representation agreement is anything to do with the person. So it includes healthcare, but it's also where the person lives and who they even can associate with. So the moment that you separate, whoever you've appointed as your power of attorney or healthcare agreement person, that's void. So it would be prudent, even in the context of a contested separation, to do a quick, certainly up-to-date power of attorney and representation agreement to make sure there's new people who can perform those important roles. So if you don't have those documents in place and you actually became incapable, it's very expensive and onerous to get somebody appointed. And so it would be very good investment of time to do a quick updated power of attorney and quick healthcare agreement. Similarly, family trusts, that's something not to forget. If you've got a family trust that was intended to sprinkle income, although this is less common since the onset of TOSI, the tax on split income rules that came out from the Trudeau government, January 2020. But if you've got discretionary family trusts that named former spouses, you're going to want to make an amendment probably to change them.
Nicole, it's been asked if you could speak a little closer to your mic so you could be heard better.
Sorry, I will fix my mic.
Thanks.
It was behind my screen, but now it's in front of my screen. Okay, can you guys hear me better?
Much better, thank you.
Okay, so you should change. So if you've got a family trust that owns property or running business or things like that, it's pretty critical that you check and make sure, who are the trustees and beneficiaries are who you want them to be. So joint retainers. So I know you guys are planners. In the context of being a lawyer, it very much depends on what your retainer agreement says. So it's not uncommon that I will do a joint retainer where I'm doing husband-wife, often reciprocal planning. And then in the middle of a divorce and or after a divorce, one of the spouses comes and wants an update. Or even, this doesn't happen that often, but sometimes they're still together and somebody wants to do some secret planning. It very much depends on what the retainer agreement says. I think our standard language says we're not obliged to let the other party know about any proposed changes after the joint retainer has concluded. So it is possible that your sneaky spouse could go back to the lawyer and make changes without telling you. And the lawyer, if their retainer agreement contemplated that they were allowed to, they don't necessarily have to inform you. So the effect of a divorce. So if you actually get divorced under the Divorce Act, that's a pretty definitive close of any entitlement under an estate. So you definitely don't inherit under an intestacy, and it's unlikely that you're going to inherit under a will unless the will specifically contemplated the divorce and provides for you. So if you mention an ex-spouse, it's treated as if they died before you. So they're just basically cut out. If a will is signed after the date of divorce, any provision for an ex-spouse is valid because they would have assumed, well, if you divorce Bob and then you decided, well, maybe I took Bob to the cleaners and I feel bad if I died, I'm gonna give him some money back. If you sign that will after the divorce, the will is not invalid because the law assumes you contemplated the divorce, right? Because you did it after. So real property considerations. So in BC, if you own property as joint tenants, and that means you jointly and severally own the property, which is very common for married people, particularly first marriage people. One of the things that can happen is a spouse can unilaterally sever that tenancy and the other spouse doesn't have to find out. So say you're joint with Bob and you're not too happy with Bob and you're getting older and you're worried you might die first, you can actually sever the tenancy such that if you die, your estate's going to go into your estate and Bob will not be notified that you've done that. So the 3 ways to sever a joint tenancy and create what's called a tenancy in common. So let me just confirm that. If you own as joint tenants, you jointly and severally own all of it. So if one of you dies, you just simply file the death certificate with the land title office and then their name's gone and then the survivor owns the whole kit and caboodle. If you're tenants in common, then you own pro rata shares according to how you're registered. So it could be 60-40, it could be 50-50, it depends. If one of you dies, your share falls into the estate. So then it's governed by either the will and or an intestacy. So it doesn't roll to the survivor. So how you can sever a joint tenancy is you can just unilaterally do it. You can do it by mutual agreement or by any course of dealing sufficient to intimate that the interests of all were mutually treated as constituting a tenancy in common. So, so this is out of a case where people were long divorced and the wife never removed hubby. She died. He ended up getting the whole thing by the joint tenancy, but awkwardly, she'd been married to somebody else for 10 years and they lived in the property. So the court found that basically there was a course of dealing sufficient to intimate that the interests were mutually treated as constituting a tenancy in common. So what happened is ex-husband got half, the new husband got half in that scenario. So a court can find through the course of conduct in a separation that a joint tenancy had been severed and the half share in the matrimonial house transfers to the estate and not the survivor. Bank accounts. So this is another boo-boo. Try to make sure that you take joint bank accounts and turn them into sole accounts. Don't forget to redirect automatic deposits and withdrawals where appropriate. So, you know, don't forget to move pensions and other beneficiary sums. So there was kind of a notorious case where a couple was split. There was an old joint account and he applied for EI, and he was fighting with the EI department, and they're like, we're paying you. And he's like, you're not paying me. And anyway, it turned out that maybe somewhat a scrupulous ex had been receiving those EI payments for quite some time, and he didn't realize that it was going into an old joint account with his former spouse who scooped the money. So again, you want to close those joint accounts. So posthumous FLA claims. So a deceased interest in family property is a statutory claim to property rights and does not abate upon death. So you're divorcing somebody, he or she dies, and it's not done. You can actually sue the estate under the Family Law Act and basically divorce the estate. There was a recent case which basically solidified this. So the parties married in 1993, separated in 2005, but they never obtained a divorce order. 15 years later, in 2020, the wife died. She had maybe gone to see a lawyer here and there, but nothing had ever happened. So there was no family law agreement, court order, or any outstanding proceedings. Before she died, she did consult with legal counsel, but basically didn't get organized. So she never, none of the family assets were in her estate because she never basically advocated for it. Was her executor allowed to sue the living separated husband? And the answer is yes, she was. So not only can you sue an estate, but a state can sue a living ex, is what this case established. So the administrator of an estate of a separated and deceased spouse may commence a claim for the division of family property and the family debt against its surviving spouse, assuming the time limits prescribed have not expired. So if you're legally married, there are no time limits. If you're common law, though, you've got 2 years after separation to file a claim, otherwise you lose an entitlement. And so I think the policy rationale is that valid claims should not be barred by death. And there is, in fact, in BC, no specific language within the Family Law Act that states that only a living person, or specifically a living spouse, may bring forward a claim for the division of family property and family debt. So the estate can sue a living person, the living person can sue an estate for divorce if they never did their family law agreement prior to death. So yeah, so I think, as I mentioned, the administrator has 2 years from the date of death of a separated and deceased spouse to commence a claim. So after the person dies, the executor has 2 years to get organized. So take-home message for clients. It's critical to update beneficiary designations, title to assets, and estate planning documents upon separation and divorce, and upon repartnering and remarriage. Otherwise, they're leaving a very expensive and messy situation for surviving partners and family members. And it can result in unintended tax consequences and assets transferring to unintended beneficiaries, and disputes and/or court applications with resulting expenses and delays for the estate and beneficiaries. So nothing that the clients want. And I ran through that quite quickly. I apologize, Linda, but I'm available for questions.
Does anybody have any questions that comes to mind? Nicole, would you say, I mean, I know that you're mainly in BC, but I know last year, I think it was last year, the rules changed in Ontario also for the will not necessarily being invalidated. So does most of it work kind of like that, as far as like for people that need to deal with it?
So my understanding is as the legislation is, like, the provinces are obviously looking at, and it's going to be uniform across the country pretty quickly. I think they don't want anomalies where what happens in Saskatchewan is radically different than what happens in, Ontario kind of thing. So it's increasingly homogenized, I guess, across the country.
Yeah, because nowadays you have people moving from province to province quite a bit, and then separating and so on and so forth. So it would be much more problematic.
The other thing I would say is, like, I think this area is a risk for claims as well, right? So if we don't give clients advice or get organized with the paperwork, or something happens and it doesn't get submitted, it will be litigated, right? So it's important that for us as advisors and professionals, that we are very careful in situations where there's blended families, there's been a divorce, there's a much higher chance if there's an error because there's a divided family, that there's going to be a problem in litigation, and nobody likes to call their insurer, right? So I guess what I would say is it's important to flag these files as higher risk files, and make sure that you follow up with the clients and document. And that's one of the reasons why we have this, and I'm happy to share that if people want. We have this post-divorce checklist. First and foremost, of course, we want to advise our clients well and make sure they don't have problems. But secondly, if they don't do it, we want to have a written record that, by the way, we've advised you after divorce, it's critical that you update title, update your beneficiary designations, close those joint bank accounts, so they can't come back and say, oh, well, make me whole because you never told me what could happen.
Yeah, it'd be great if you could share that. One of the other questions I had was obviously sometimes from start to finish, it takes some time to go through the process for clients. So what happens to them when they're in the process, and so they haven't signed the separation or the divorce agreement, and something goes wrong? Because I mean, obviously life happens, and there'd be some.
So I've had a couple of those files in my office, and basically the executor takes over and finishes the divorce. So I've had a few. So somebody dies in the middle of a family law matter, the executor takes the place and basically finishes the divorce. So in here we have a law firm, but we also have a trust company. And as the trust company, we've completely divorced people as the trust company.
Okay.
So it's always, it's always interesting, but I think it's unpleasant on a good day to do a divorce. But when you've got a financial institution that's divorcing you, it's, I think, less than ideal. I mean, maybe it's better because there's less emotion. But we had one where we were appointed comité. So in British Columbia, when somebody becomes incapable, the court appointed guardian is called comité. So there was a lady that was really having memory issues. Her husband wasn't, I don't know, I guess, ready, willing, and able to take care of her, and decided he was out. So she basically got stuffed at a care facility. And then we basically, as a court-appointed guardian, did the entire divorce against him while she was in a care facility.
And during the process of those kind of things, do those questions go to the clients? Because I mean, personally, the experience I have had, nobody's talked about that in the middle of the process, because basically it would revert to whatever they already had, if I understand correctly.
Yeah. So for that one, we were court appointed. She didn't have a power of attorney. So but yeah, whoever the executor was. So in a husband-wife reciprocal will, and then they're divorcing. So the spouse is going to be invalidated. So then it's going to be the next person, right? And so maybe the person is, so say it's wife, she dies, and they had appointed each other, and then husband's brother. Well, the husband's brother isn't going to be appropriate. Right? So he's then going to be passed, and then again, it could be a court-appointed executor, and so Heritage Trust is our trust company. We actually have often done that because we get chosen, because we also have a law firm in here that does family law, right? So
right.
And I mean, yeah, it's less than ideal. I mean, death and divorce at the same time, that's a bit depressing. Death, divorce, and taxes.
Yeah, it's sort of the everything you dread.
Yes. But anyway, here's the thing. Some things are inevitable, but I think what we can choose is how we deal with it. So it can either be less expensive, more organized, less stressful, or if you avoid it, like everything in life, it's a monster that just gets bigger, right? So again, I think the thing with clients is the more proactive and organized you can be, the easier and better it's going to be for you and your beneficiaries after. So it's what I say to clients is it's like you don't want to be contemplating like esoteric questions of mortality because that just immobilizes people. So
Sure.
what I say is, look, just treat it like one of those annoying adult things you have to do, like brushing your teeth or getting your car serviced or whatever. It's just like, don't overthink it. Just put it on the checklist, get it done. Roughly right is 100% better than not done at all.
Mm-hmm.
And then just put it in a drawer and hope you don't need it, right?
Because based on what you're explaining, some of the things in your presentation, it sounds as though the legal costs would probably be much more exorbitant if you're having to actually battle it out as opposed to having a document that makes sense.
Yeah, and on top of that, I mean, you think, we work hard our whole lives, try to leave something and like how unfortunate would it be if your money goes to somebody totally different than who you wanted. So another one on the Heritage Trust side, which was it was a very successful physician, and she loved animals. So she was a single lady. She loved animals. By all intents, we think she would have left money probably to the SPCA or similar, but she was not super old, and I don't think just hadn't gotten organized yet. And she unfortunately died suddenly. And so it went in an intestacy to 50-50 to each of her siblings, neither of whom she had spoken to in 30 years. And she left like a substantial estate. Like she had paid for a home, she had substantial investments. And so those siblings got 7-figure windfalls, right? So that's, again, just say to clients, even if it's sort of a blunt instrument, it's 100% better than nothing. Right?
Mm-hmm. Yeah, for sure. I mean, a lot of people certainly wouldn't like something like that if you hadn't spoken to somebody for a really long time.
Well, that's it.
I guess so, unless anybody else has any other questions that they would like to pose.
I think it's the end of the day for you guys, so maybe it's good we went through.
Yeah.
You can share my slides. I'm happy to do that. And
okay, great.
And also, if you've got questions, I'm happy to chat with people. If people ever want to, I'm happy
Sure.
to do that. So.
Absolutely. So one last chance here for questions before we wrap up our day and that sort of thing. And you lose Melanie's brains.
Nicole.
Oh, Nicole, sorry. Melanie was the lady before.
A long day, I know.
Okay, well, thanks very much, Nicole. I think it's been very interesting. It would be great if you also shared the checklist. I know that we have a checklist too, but it's always good to make sure that there's nothing missing on ours.
So what I'll do is as soon as we're done, I will email it to you, Linda.
Okay, that sounds good. Well, thank you and enjoy the rest of your day.
Okay, thank you. Thanks, guys.
Yeah, bye. So thanks to everybody who participated today. I hope that maybe as Taryn said, that the one or so things you take away with you and put that into your practice. We will be distributing the recordings, the presentations, etc. And are happy to hear any feedback or any topics that you'd like to hear of in the future. So,
okay, thank you.
Thank you. Bye-bye.
Bye.
Thank you.
Bye.
Thank you. Thank you.
Thank you. Have a good afternoon. Bye.
Bye.
Bye. Thank you.
Thanks a lot.